All right, welcome to the show. Today is part two of Judge Bryant, and we're gonna see other things. With this one's a continuation of what was being said yesterday, so nobody misses out. Uh, Judge David Wolf, we have a case, Sarah Fuson, State versus Sarah Fuson, that is being heard in Judge David Wolf's courtroom, and that's going to be a big one. It's going to be big for this channel, but I know I can handle it. So let's get started with this.
Did you have permission by Mr. Estes to strike Mr. Estes?
No.
Your Honor, defense is satisfied.
Satisfied. Court is satisfied. I would accept a guilty plea of one count of assault or assault battery. Mr. Murad, I know you want immediate sentencing. Unfortunately, due to the victim's right to make a statement, I cannot impose immediate sentencing. But what I will do, Ms. Ritter, do you have contact information for that? This is the victim that showed up.
I do, yeah.
I will try to do a quick turnaround for a Zoom sentencing on Wednesday and give Ms. Ritter an opportunity to contact the victim and see if they want to make a victim impact statement, but I have to allow for the victim to make a victim's impact statement.
Wednesday, what?
Mr. Moran, he'll explain it to you. I said I can't sentence you right now, because the victim has a right to come in and make a statement. But I'll send you back to the breakout room. Mr. Murad, if you could explain that to him, but I'll bring him back Wednesday. I'll let the prosecutor contact the witness and see if they want to make a statement.
Thank you, Your Honor. And that's the 13th of this month, correct?
Yes, 13.
Thank you very much, Judge. I'll explain that to Mr. El-Saidi in breakout room.
Okay, I'll send him back.
Thank you.
All right. All right. I'll put that on for Wednesday. Yeah. Mr. Dox?
Good morning, this is Mr. Doc's assistant, and he's coming right now. He's in the other courtroom. He's coming out.
It's only one person can let the assistant check in for him. That's Daniel. Yeah, P number P2 something.
Good morning, Your Honor.
Mr. Dox, P number 2 close to mine for him to be talking about his assistant checking in. Good morning, Mr. Dox.
Good morning.
I'm ready on Allen. We thought your representation had ended. So please accept my apology. I sent your client in to speak with the defender's office. So he did speak with the defender's office this morning, but please accept my apology for that. This is case number 215615901, the People versus Kenyatta Jawan. Allen, defendant, is charged with one count of weapons purchasing without a license. Today is the date set for review. Mr. Dox, your appearance, please.
Good morning, Your Honor and Honorable Staff. Attorney Quentin Dox, P number 79657, on behalf of Mr. Allen. Mr. Allen, please state your full name for the record.
Kenyatta Jawan Allen.
All right. Somebody gave me a paper. Y'all know I will lose paper. I will lose paper. Did I give it back to you by mistake?
Yeah.
Oh, okay, thank you. All right, today's the day set for review, and I have an update from Ms. Bumpus. Stating that I placed Mr. Allen on a 9-month probation, and I did that back in 2022, but on May 16th, I extended his probation to November. He has completed 3 sessions of anger management, and he still owes $400 on this case and $2,100 in total to 36th District Court. Do you want to just continue him to his final review date and see?
Yes,
if
Your
he
Honor,
can-
please.
Okay, all right, and then we'll switch it back to Mr. Dott's name. All right. All right, so let's get it done, Mr. Allen, okay?
Yes, ma'am.
All right,
Thank
so I'm gonna continue you to November 16th, at 10 o'clock AM, and then let's finish that anger management. You need to, if you can't pay the total that you owe to 36 District Court, you need to sign up for the payment plan, okay?
Okay, and how do I do that, Your Honor?
Talk to your probation officer, they'll help you sign up for the payment plan.
Okay,
All right,
Thank you, Mr. Allen. You're all set. Well, if you have any questions, call me, Mr. Allen.
okay, thank you.
all right, good to see you, Mr. Doctor, have a great day, stay safe.
Good seeing you too, Your Honor. Stay safe.
All right, thank you. All right. Okay, who is this? I'm watching. Tell the lawyers I'm ready.
Lawyers, the judge
oh.
is ready.
They supposed to be here, but I'm not gonna be able to do them. Mr. Murad,
Yes, Your Honor.
do you see the person that's in the waiting room? Don't call their name. It's a HIDA case. Do you see
Yep.
them? Do you all have a phone number for that person? Ms. Stevenson?
I don't have it with me, Judge.
Well, let's rename the person. I'm gonna rename them, bring them in, and then you talk to them in the waiting room, but I'm getting ready to start my trial, okay? Did we get a report on that person?
I didn't see that one.
So Judge, we're just getting them a new date?
Yeah, let's give them a new date. Let me see if I got a report. I did. Oh, it's good. He doesn't have any remaining conditions and he is, I think it's his discharge date. He's gonna be discharged.
Judge, can we just waive his appearance and I can send them out?
Yeah, well, I'm gonna just discharge him, but, let's let him know what's going on.
Will do.
I'll bring him in the break, I'll bring him in, and then you can, just tell him what's going on, okay?
Did you send it to me and I overlooked it?
I don't know.
Oh, okay,
No.
all right.
Oh, I did forward it to you. But, I forwarded it to you Friday at 1:59 PM. I was working early, I was getting it done early. The person I just let in the breakout room, in the courtroom, please accept to join the breakout room. All right, they're discharged, Mr. Murad. Okay, then I'm ready. Turn the camera away from me. All right, this is case number. And then zoom it out like, I guess. This is case number 184543303, the people of the state of Michigan. Strike that, 3301, the people of the state of Michigan versus Keith Wayne Ditmore. 02, the people of the state of Michigan versus Corey Devon Spencer. And 03, people of the state of Michigan versus Derek William Abramski. The defendants are each charged with one count of assault aggravated. And as to each defendant, today is the date set for waiver trial. Appearance, please, on behalf of Mr. Ditmore.
Roger Free on behalf of Mr. Wayne Keith Ditmore,
And your P number.
A62269.
And Mr. Ditmore, your name.
Keith Wayne Ditmore Jr.
Thank you. On behalf of Mr. Spencer.
Your Honor, Jeffrey Sherbo, P25324, on behalf of Mr. Spencer, without an assistant calling it.
He was trying to let me know, Judge, I'm P2 too, so I'm gonna get away with some stuff during this trial. We're gonna see.
Well, just the last guy.
I know. With a P79. Mr. Ditmore, please state your name, sir.
Mr. Spencer,
I'm sorry, Mr. Spencer, yes.
Corey Devon Spencer.
Thank you. And on behalf of Mr. Abramski.
For the record, Your Honor, Janice Stevens, P57708, appearing on behalf of Mr. Derek Abramski. Mr. Abramski, please tell Judge Bryant your full name.
Derek William Abramski.
All right, today is the date set for waiver trial. With respect to the trial, are there any preliminary issues before we begin? Gentlemen, you may be seated.
Judge, I didn't know.
Oh, you did?
Yeah.
Oh, you're right, I did. Isn't that something? And I'm a stickler for the people going first. You mean I let all three of these people put their appearance on? Ms. Ritter, don't take it as anything other than, I don't know what to take it as. Ms. Ritter, your appearance, please.
Thank you, Your Honor. Good morning, Christina Ritter on behalf of the people, P number 8505. Your Honor, I also have my officer in charge, President of the courtroom, who's standing up to my right.
Morning, Your Honor. Detective Derek Mason.
Thank you. All right. Again, I apologize, Ms. Ritter. Are there any preliminary matters before we begin?
Just a couple on behalf of the people. One, people did file an amended complaint with the court, adding the lesser included offense of count 2, assault and battery. I did get notice and copy of those amended complaints.
And I do see it now on my desk. Any response from any defendant with respect to the amended complaint?
Your Honor, on behalf of Mr. Spencer, and for the purpose of the reporter, should I indicate my name each time or?
No.
Okay. I just find it absolutely incredible that we've been here for 5 years and we get this today. I understand that it may in fact be a lesser included offense, but we had one charge and that's what we've been coming for. You've had final pretrial conferences, and to amend it on the day of trial, I think would be improper.
Anyone else?
I would agree, Your Honor, on behalf of Mr. Ditmore, Your Honor. Just when it said 5 years, it's over 5 years, Judge, since it had happened. And we've had numerous court appearances, appeals on certain issues. And it's just another example of them trying to harass and intimidate the defense judge to add this charge now. We would raise our objections for the record.
And anything on behalf of Mr. Brown?
And for the record, Your Honor, I do understand that people have, this is not, it's not untimely according to the court rules, Your Honor, but I would concur with Brothers Counsel that we've been at this for a number of years at this point. And I do, I have the highest regard for Ms. Ritter and the way she practices law, Your Honor, but we do believe it's a little bit, the ninth hour to come with an amended charge, even if it is the lesser included offense, Your Honor. We take it as a surprise, but I do understand it's not outside of anything that the court will permit her.
All right, court is going to allow the amendment as the court rules to indicate that people have a right to amend the charges up to, through, and including trial. The court allows the amendment. Anything further?
Yes, Judge. In addition, Your Honor, I did speak with Sister and Brothers Counsel regarding the photos of the injuries sustained by the complainant witness, and they all have stipulated to the
On behalf of, just say it in the order that you again, because this is 312.
Okay.
312.
On behalf of Mr. Abramski, Your Honor, having had the opportunity to confirm with people with regard to the photographs of the alleged injuries, Your Honor, at this point we are going to stipulate on behalf of Mr. Ritter.
On behalf of Mr. Ditmore.
We would stipulate, Your Honor, would ask the court just to let us cross-examine before we admit it in at that
Absolutely.
time.
And then on behalf of Mr.
I would have no, Spencer, Your Honor, I would have no objection to that procedure. I assume it's the photos that have been previously provided.
Absolutely, and she'll show you before she
Right.
presents it.
And with Mr. Farina's proviso, absolutely no problem.
All right. Anything further?
One last thing, Judge. So during final pretrial conferences, there was a stipulation by people for the medical records that were, I guess, obtained by the complainant witness on the day of the incident. And the people did stipulate to the copy that was provided in the summary. However, Mr. Sherbo just showed me another version of the medical records that the people stipulated to people are not stipulating to the version. Sherman has provided, them, but that's not the same. as what's in the set.
And is that something that's gonna come up, now or in defense case?
Well, it's gonna come up, Your Honor. First of all, I don't disagree that this isn't a different set. This is the full set that was subpoenaed in the civil case from, the certification to the end. The records that were provided in discovery, assuming they're the records we have, they do have the pages of interest to us, which would be pages 20 and 21 on the documents I gave Ms. Ritter today. If you look to confirm, those are the pages that showed that there was a blood serum, blood alcohol content of 0.245. And that's really the only page. The rest is superfluous, although I can't say that.
So, I mean, this is the way I'll handle it. I don't know how it's gonna come into play. If there's something in the record that the people have not stipulated to, that is, being presented to the court, then I'll address it at that time. So the record that you stipulated to, Mr. Sherbo says, is included in the record that he gave you, which it sounds like you're saying the record that you gave her is a complete record. And the other part that she stipulated to was partial of that complete record.
As I understand it, yes, Your Honor. Again, and I can't find my copy of this record today, pages 20, really page 20 is the only page we need because it says on the bottom ethanol serum 0.242. And that's the emergency documentation. I believe that was in the stuff that we got from the prosecutor's office. Really, I just wanted a complete copy, but page 20 is the only one.
I have the 4 pages that you're talking about
Okay.
included in that they did give to us, Judge, which has the 0.242 alcohol ethanol.
All I'm saying is, and I'm not saying that the other pages are not admissible. What I'm saying is, as it relates to the people's stipulation, I will receive the pages that she stipulated to. If there are any other pages, she can consider stipulating to them. And if not, depending on how they're being presented, you may have to bring in the keeper of the record.
Okay, on behalf of Mr. Benson, before the court just rules on it, can I just have a quick conference with Ms. Rick?
Sure.
I want to make sure that.
Right, that's why
you came out.
I came upstairs.
Okay, yeah.
I mean, I pushed it, the light came on, then I thought I missed it, but it's down, that's why I walked, instead of walking all the way down to the.
Down for a few days last week too.
Okay.
That's the date, so it's.
Great.
All right, anything further?
Not from us, Your Honor.
Nothing on behalf of Mr. Benson.
One last thing, Judge, I'm not hoping I plan on using one of the photos, so I don't know how to.
They said they stipulated.
Oh, okay.
But I don't need to see, I might not need to see it in the opening, but if you, let's just go with it. There are many witnesses, nobody asked me for sequestration.
I'm standing up for it.
Oh, okay,
Look for sequestration of witnesses.
all right, and, Ms. Ritter, are you requesting an exception?
Yes, Your Honor, with the exception of my officer in charge, who is present, Detective Mason, who is then the officer in charge on the original cases.
Right, and he's the reason why I adjourned my trial, that I wasn't happy with, your OIC, but we're here. Okay, we're here and we're ready to proceed,
I'm trying to
okay?
see if I have an objection to that.
You can place it on the record, but I'm gonna overrule it.
All right, well, never.
All right, the motion for sequestration is granted. And the people's request for the, exceptions for the OIC is also granted. So, if there's anyone in the room that will testify today or in the future on behalf of the people or on behalf of the defense, with the exception of the officer in charge, you must leave the courtroom. Additionally, everyone is prohibited from, so I am live streaming the trial, and everyone is prohibited from watching this trial on YouTube. I am going to question every witness that takes this witness stand under oath as to whether they have viewed any portion of these proceedings on YouTube, okay? Anything further?
Yes, Judge, one other.
Oh, yes.
We have a witness, Ms. Paris Floyd, that's out in the hallway, subpoenaed by the prosecution. But she can't testify Wednesday when we've got our case, but can we have her testify tomorrow afternoon? She's out of town, that's her job. She's here and she can testify.
Mr. Farina, can I ask you one favor?
Yes, Judge.
I might ask you another one, but right now,
Yes.
plexiglass is still real and I can barely hear you.
But what I was saying, Your Honor, is that Ms. Floyd, who's a witness called by prosecution and used by us as well, is in the hallway. She was subpoenaed for this morning, but we'll need her for Wednesday. Sorry, she can't testify Wednesday. We probably need her for tomorrow afternoon, so we'll have her come back tomorrow afternoon.
Do you think, is that someone you're using?
Judge, the people just subpoenaed the intended witnesses.
Oh, okay.
And to provide them for some people there.
Oh, that's a police officer or something?
No, she's,
Oh.
she was an eyewitness at this.
Oh, okay, but she won't be needed until
Right,
tomorrow.
Yeah.
She can be released, the people, now, I don't want dead space though. But, okay, she can be released and told to come back tomorrow, you saying afternoon?
Afternoon, say 2 o'clock, that'd be,
Sure,
okay. I'll let her know, Judge.
okay,
And also, Your Honor, tomorrow we have an expert coming, and if I would ask the court to allow him to testify out of order, if the prosecutor's not ready, he's available from 9 to 11, or at least in the morning tomorrow, and we're having him come in, that I've identified to Ms. Ritter. So if we're not through her case today, whether that would be a problem, based on his availability. His name is Kenneth Bora, and also, Your Honor, there is another person in the courtroom, his name is Michael Sherbo, who's
oh, he doesn't
P74882.
get an assistant, that's your assistant, right?
I'm trying to keep him off the streets. But here's my son, Michael, and he returned from Charleston, is not working, so. I just-
Okay, awesome. And then, do we know who the young lady is in the back and forth?
Yes, ma'am. Support.
That is
And,
a mom.
Okay,
Mom from Mr. Dick.
okay, and she will not be testifying.
No,
Okay, all right. With respect to calling the expert out of order, I guess if we go ahead and get started, Ms. Ritter might be able to get finished. Okay,
Should we
I'll let
tell-
my witness.
yes, let your witness know, and while you're doing that, the people may, oh, no, it's open statement first. All right, will the people be making an opening statement? All right, you're all set, Mr. Farina?
Yes, Your Honor, she'll be back at 2 o'clock tomorrow.
Okay, thank you. All right, I think we've covered all the preliminaries. The people may start, begin your opening statement.
Thank you, Your Honor. Your Honor, on April 20th of 2018, the complainant witness Christopher Floyd headed downtown and met with a couple college friends. The plan was to go out, have a couple of drinks, have a good time with his friends downtown. And eventually, Mr. Floyd and a couple of these friends ended up at the Coliseum bar located on 8 Mile in the city of Detroit. Now, Mr. Floyd and a couple of his friends arrived at this bar about 9 o'clock that night on April 20th of 2018. And you'll hear testimony, Your Honor, from the complainant witness, Mr. Christopher Floyd, as to how he went into the bar, him and his friends were in a booth. He was there for about 40 minutes to an hour, and then he released himself to go to the restroom. Now, Your Honor, there is no testimony from the complainant witness that when he comes out of the restroom, that's when he comes in contact with the 3 defendants that are in court today, Your Honor. Mr. Floyd testified that when he came out of the restroom, he came in contact with Mr. Corey Spencer and another individual who grabbed him by his arms to restrain him. He'll testify that Mr. Didmore approached him and began punching him continuously in his face. And he'll also testify that Mr. Abramski soon approached and again was punching him continuously in his face. Your Honor, the people have been dealing with this case since 2018, which brings us to about 5.5 years now. I want the court to pay attention to the testimony given by the complainant witness today. And that's important, Your Honor, because like I said, 5.5 years, we're still in court trying to figure out what happened to Mr. Floyd that night at the Coliseum Park. And Your Honor, the people kind of compared this case to a puzzle with one missing piece. And that missing piece, Your Honor, hopefully the people tend to prove to this court that on that day, Mr. Floyd came into contact with 3 defendants and they assaulted Mr. Floyd continuously outside of the restroom at his bar. You'll hear testimony, Your Honor, from Mr. Floyd that he was punched in his face several times by Mr. Didmore and Mr. Abramski, that it caused his eye to swell and blood running down his face during the time of this assault. Your Honor, the people tend to call Detective Mason as well, who was the officer in charge of this case, and he'll testify to the court as to his role in this case. Like I said, Detective Mason has been on this case since 2018, so he'll explain to the court how we come to this court today with these 3 defendants sitting in the court. Now, Your Honor, the issue that arises from this case comes from identification and intoxication. Now, those 2 issues will be presented by defense counsel, and they'll tell the court that Mr. Floyd was so intoxicated that he couldn't identify any of the parties. That Mr. Floyd mistakenly identified one of the defendants, and therefore he misidentified the other defendants. But I want the court again to pay attention to the testimony that will come through from the complainant witness, who will give a detailed account of what happened on that day in the Coliseum bar, and Detective Mason, who will walk the court through the process and how the lineups were conducted in order to get these defendants identified in court today. Your Honor, the people also tends to bring in a video interview from a statement made by Mr. Didmore. And Mr. Didmore actually comes into the police precinct voluntarily and makes a statement to Detective Mason. So, Your Honor, once the court hears the testimony from the witnesses, once the court sees the photos that people tend to bring through as exhibits to corroborate the events that Mr. Floyd will testify to, and once the court hears the testimony from Detective Mason, the people hope that the court can put that last piece of the puzzle into this picture as to why these 3 defendants are here in court today. And once the court takes all of that evidence into consideration provided by the people want this court to find Mr. Didmore, Mr. Spencer, and Mr. Brandt guilty of count 1, aggravated assault, or in the alternative, the lesser included offense, assault or assault battery. Thank you.
Any opening statement at this time on behalf of Mr. Didmore?
Yes. May we go out of order, Your Honor, and I'll go first?
You may.
Your Honor, again, for the record, Jeffrey Sherbo on behalf of the defendant Corey Spencer. Your Honor, I feel like I just went to a library and went to the fiction column. The facts are so different that will be established before this court that this court could find nothing but reasonable doubt. What's interesting in the testimony will show that Mr. Floyd, the complaining witness in this matter, I don't want to call him the victim, but the complaining witness, blew at 12:36 at night through blood serum of 0.24. Tomorrow, Dr. Kenneth Bora is going to be here and will testify that based on what the real testimony will be from Mr. Floyd, because clearly 5 years later, we can't remember what he said 5 years ago, because 5 years ago, he said he got there at 9 o'clock. That 5 years back, so that 5 hours back from, 3.5 hours back from 12:36 to 9 o'clock, we'll take that 0.24 to a 0.32 to a 0.35 at the time of the alleged incident. What my esteemed colleague fails to tell you that the testimony will not support, other than Mr. Floyd's unsubstantiated testimony, that he walked out of the bathroom and he got jumped for no reason whatsoever. What the testimony will show is that Mr. Floyd was in a drunken, out of his mind condition, takes a young lady into one of those back rooms that I've never seen in my life, Your Honor, and then grabs another lady, Miss Paris Floyd, not related, goes into the back room, and the testimony will say, quote unquote, he was just a drunken fool. There's an issue in the back room. Mr. Floyd comes out. He is so intoxicated, he goes after one of the bouncers, ends up being restrained, not by Mr. Spencer, falls to the ground and hits his head on a table and a wall. Then you're going to hear so many inconsistencies in terms of reasonable doubt, but some of those that are really key. There was no identification that night. There was somebody on behalf of Mr. Floyd goes into the bar, takes pictures. There's a ruse performed by the detectives in this case by getting their cabaret licenses and trying to create a photo array. During the photo array, 3 people are picked out of the photo arrays. 2 of them were employees, but not there that night. And the testimony will show Mr. Faison, who's already been dismissed. Mr. Abramsky wasn't even there that night. And then there's some guy whose picture nobody knows, a guy named Michael Sullivan. His picture circled with Floyd. So within a month, there are 3 different photo arrays, 3 wrongly identified people by Mr. Floyd. What's so significant to that is when Mr. Floyd is interviewed by the police, might have been Mr. Detective Mason, he says, I came out of the bathroom, a brother grabbed me who had dreadlocks like the Predator.
No, no, did. What makes sense?
That's what his testimony is going to be. I'm assuming that's what it's going to show. And then he says, so there's a guy with dreadlocks, he says, he can't identify. And then somebody else grabbed me from the right, but I don't know who it was. And then some white guys came at me from the front. That's what his testimony is. So for the first 72 hours, he doesn't know who it is until there's these created photo arrays. There's no testimony that the complaining witness can identify anybody. That coincides with the executive functioning deficits that he has when he blows a 0.35 that Dr. Borer will testify to. So during the course of the trial, we're going to, obviously, we have impeachment available testimony for Mr. Floyd because we have sworn statements that he's taken that will be used. There's going to be the evidence of my client. There will be the evidence of the other defendants. We've got 2 guys that weren't even there who are going to testify. So we asked the court, remembering that this is still a reasonable doubt standard, that there is no way that there can be anything but reasonable doubt when you hear the testimony. Thank you.
All right. Any opening statement on behalf of Mr. Bigmore?
Yes, Your Honor. If I may proceed, Judge. Your Honor, my co-counsel's characterization of this as fantasy would be more accurate. It's not an issue of simple identification intoxication. When Mr. Floyd started drinking at 6 o'clock by himself, before at Flood's, bar, then he goes again drinking at Greektown, then he goes to the club. Yes, his alcohol level at 4 hours after the incident is 0.24. Yes, I get that. What happens in this case though, Judge, is that leads to a fantasy and focusing on reasonable doubt. When you show up and you say that a predator grabs you from behind the neck with dreadlocks, 2 bouncers grab each arm who don't necessarily know much about each other, have formed no mens rea to attack you. You have no argument with them. You come out of the bathroom, one's holding an arm, one's holding another arm, one's holding you in the neck, one stands in front of you, 2 stand in front of you, the white men stand in front of you, the black men hold your arms, and then they start punching. No reason. It makes no sense. These are people who are employed to keep security, to keep the peace. There's no history of aggression between them and the complaining witness. It makes no sense. It's bizarre. The dancer will testify she was there. She was 1 or 2 that he brought to the back, didn't pay, threw the money, but not enough, and caused a disturbance. He then pushes past one of the bouncers and takes a swing at another one. He's then restrained. He is big, and he starts fighting. He created the situation that led to his injuries. He was the aggressor. He put himself in that position by consuming. That's where the intoxication comes into place, and other issues as well, such that he can't even create a plausible version of what happened. That's what we're dealing with, Judge. And if he was injured, and when he was injured, that's his cause, his fault. He's the aggressor. And that's why we're here today. But you know what's interesting also, Judge, and I want to finish up by saying this. 5 years. 5 years of fighting this. My client's gone through hell defending himself and finding the money to try and survive and make this thing work. It's affected all of their lives. All my client and all the people did was to do their job. They don't get paid by fighting people. They don't have protection of the club. There's no motive. There's no mens rea. There's no reason to attack you. But you know what? You keep pushing. You have an assistant as a police officer. You have influence with other ways to push this case and put pressure and not give up and put pressure on everybody and get your way. NFL player, yeah. I get my way. I played for the National Football League. I get my way. That's what this case is about. Bullying and pushing and ignoring there can be no other reason, no other alternative of what happened that night. Only my way. That's what we're dealing with the Floyd. Thank you.
On behalf of Mr. Brown.
I guess I'm gonna go ahead and take exception to the people's suggestion that what we have to do here is try to figure out what happened. Because I don't think that that's what has to happen. I think that the people do have a burden of proof beyond a reasonable doubt as to what happened. And I believe that the proofs are gonna fail to support the people's verdict. Your Honor, I don't want the court to gloss over the identification and the intoxication issues here. Because the fact of the matter is that the people they have to prove all the elements of the crime, but first they have to prove that Derek Abramsky was even present. And they have to do that primarily through the identification made by the complaining witness, which they're not going to be able to do. We believe the proofs are going to show, Your Honor, that shortly after this incident occurred, the description that is given by the complaining witness of the person who's supposed to be the white male is vastly different than the physical description of Derek Abramsky. We believe that the complaining witness has an absolute motive to fabricate and that there's pending litigation that's riding on this case, Your Honor. He's intoxicated, he has this lawsuit pending, and the identification that he gives shortly after the incident is wildly different from the way that Derek Abramsky looks, Your Honor. We believe that I would agree with Brother Counsel that there's absolute bullying going on here at the part of this complaining witness. That we believe that the evidence is going to show primarily through Detective Mason that Mr. Floyd was absolutely dissatisfied with the progress the Detroit Police Department was making with regard to the investigation. So he goes and takes it upon himself to go do his own investigation, and the result of that investigation, Your Honor, flawed as it was, because he's not a professional, we get this photo array concocted and put together. And the people's case rests upon that kind of activity, that lack of credibility, that level of intoxication. And we believe, Your Honor, as the end of the proofs, that the people will have failed to meet their burdens, not to try to help the court figure out what happened, but they will have failed to meet their burden of proof beyond a reasonable doubt that Mr. Abramski, that's the only one I can talk about right now, committed any assaultive activity. They're not going to be able to prove that he's guilty even of being there, Your Honor. And we're going to ask you to find him not guilty.
May call first. Thank you, Judge. At this time, if you would like to call Christopher Floyd to the stage.
Oh, look like the OIC. Step to the court reporter right here. All right, step this way. Raise your right hand. Sir, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. All right, you may be seated. All right. Okay, Chief, may proceed.
Thank you, Judge. Good morning, Mr. Floyd.
Good morning.
Mr. Floyd, can you state your full name for the record, please?
Christopher Michael Floyd.
And Mr. Floyd, I want to take you back to April 20th of 2018. Do you recall that day?
Yes.
Okay, and on that day, were you in the city of Detroit?
Yes.
Okay, can you start by telling the court, what did you do at the start of that day?
Starting that day, I had plans to meet with a friend later that night. So you want me to start like from the beginning? I just remember being outside and doing my lawn and being sort of in a rush to get downtown to meet up with my friends.
Okay, so who was this friend that you were meeting up with downtown?
Sam Sword.
Okay, and were you meeting up with anyone else downtown?
He was the only one who I knew, just Sam Sword.
And where were you meeting Mr. Sword at downtown?
We had made plans to meet at Floods.
Okay, and around what time did you arrive to Floods downtown?
Approximately 6 o'clock.
And that's at 6 o'clock in the morning, 6 o'clock in the evening?
6 o'clock p.m.
Okay, and when you went to Floods, did you travel there alone?
Yes.
Okay, and what happened when you got to Floods?
Well, prior to getting the Floods, I did talk to Sam Sword, and he told me that he was running late. He had friends that came over to his hotel. So I knew he was staying at the casino hotel down the street from Floods. So I drove there and I parked my car and I walked down Floods.
Okay, did you walk alone?
Yeah.
Okay, and just to go back just a little bit, Mr. Floyd, Sam Sword, you're referring to him as your friend, correct?
Yes.
Okay, how long have you known Sam Sword?
Since 1994.
Okay, so this is a long
Long
time
time,
frame. Okay, and you walked to Floods by yourself.
Yes.
When you got to Floods, what did you do?
I sat at the bar.
Okay, and did you order any drinks or food at the bar?
Yes, I did. I ordered drinks.
Okay, do you recall how many drinks you had at Floods?
Maybe 3.
3 drinks? Okay, and how long did you stay at Floods bar?
Approximately an hour.
Okay, and for this whole hour, were you alone or did your friends meet you there?
I was alone.
Okay, so what happens after this hour passes?
I walked down to the casino hotel and went up to visit Sam in his room.
Okay, and how long did you stay at the casino hotel?
We stayed there maybe an hour and a half, 2 hours. It was Sam and he had a group of guys that we had grown up with.
Okay, do you recall the names of these?
I don't know their names.
Okay, do you recall how many other individuals there were?
4.
So in total, how many of individuals were with you?
6.
6 altogether.
6 in the hotel room.
Okay, so 6 plus you, that's 7 individuals.
No, I make 6.
Oh, okay, so altogether it's 6 people in the hotel room.
Yes.
Okay, and you testified that you guys stayed there for about an hour and a half?
Hour and a half to 2 hours.
Okay, during that hour and a half, 2 hours, did you do anything in the hotel?
Drink water.
Okay, and did you drink or eat anything else?
No.
Okay, and what happens after this hour and a half to 2 hours passes?
We hopped in a van and it was their plan to go to the Coliseum.
When you say their plan, who are you talking about?
Sam and his party, people he.
Okay, and did you decide to go to the Coliseum as well?
Yeah.
Do you recall about what time you guys decided to go to the Coliseum?
That would have to be between 8:30 and 9.
Okay, so you said that, well, let me ask you this. How did you get to the Coliseum?
We all took a van.
Okay, and do you recall what time you arrived at the Coliseum?
It was shortly after 9.
After 9?
Yeah.
Okay, and do you recall where the Coliseum bar is located?
I know it's on East 8 Mile, on East 8 Mile.
Okay, is that the city of Detroit?
Yes.
County of Wayne?
Yes.
Okay, and what's at the Coliseum, do you know?
Coliseum is a adult gentleman club.
Okay, and have you been to the Coliseum before?
No.
So this is your first time at the Coliseum?
Yes.
Okay, so are you still with these 5 other individuals?
It wasn't. It was 4 of us now in the car.
Okay, so altogether it's 4 individuals.
Mhm.
You arrived at the Coliseum.
Yes.
What happens when you arrive there?
We valeted the van. We walked in and they checked our IDs and I didn't have cash on me, so they paid my way to get in.
When you say they, who are you?
Sam Sword.
Okay, so when you say they checked your ID, do you recall who checked your ID?
I don't, it was an attendant at the front, at the door.
Okay, and do you see that person in the courtroom today?
No.
Okay, so this person checks your ID, you go inside of the Coliseum, correct? Can you give a description to the court of the inside of the Coliseum when you first walk in?
So like there, when we walked in and they paid the fee to get in, there's the door, we walked in the door. And what I remember is it's almost like you're on the platform and then straight ahead to the left is the bar area. And it's a seat area, and then to the right is another platform where it's kind of like a private booth you can sit. And that's what we were waiting for the booth to be clean, so we stood there maybe 10 minutes until the booth was clean and they set us down.
Okay, so you go inside and you sit in the booth, correct?
Yes.
Okay, how long do you sit at the booth with these other individuals?
I was probably at the booth 5 minutes.
Okay, and during your time at the booth, did anything happen?
The bar service person came over, took our drink order,
Okay,
and After they left with the drink order, I got up from the booth and walked to the bathroom, to the
Okay,
restroom.
okay, so you say you were seated for about 5 minutes and then you get up and go to the bathroom?
After I make the order the drink.
Okay, and during this time in the Coliseum, are there lights on or,
It's dimly lit.
okay,
There's lights on, but it's dimly lit.
okay, so is it kind of dark in there?
It's not dark. It's not dark. You can see well, it's lights everywhere in the Coliseum. It's like stage lights, and so you can see.
Okay, and you said you go to the bathroom, correct?
Correct.
Do you recall where the bathroom was located from where you were sitting?
Yeah, so I had to walk down like a small flight of steps and straight ahead, walking toward the rear of the Coliseum, and then the bathroom is off to the left.
Okay, do you recall, any other rooms being near that bathroom?
No.
Okay, so what happens after you go into the restroom?
Well, on my way to the restroom, I mean, I'm very noticeable of things. But heading to the restroom, when I was walking into the restroom, there was a guy walking out the restroom.
Okay, do you know who this guy was that was walking out the restroom?
No, I don't.
Okay, do you remember how this guy looked that was walking out the restroom?
He was taller than me. He wore a baseball cap, a Detroit baseball cap.
Okay, was he African American or Caucasian?
He was African American.
Okay, and so you go in the restroom, how long were you in the restroom?
Maybe 3 minutes.
Okay, and what happens after you come out of the restroom?
When I walk out of the restroom, as soon as I step out of the restroom, my foot hit the floor, and I'm surrounded by the security guards there.
Okay, and do you recall how many of the security guards were surrounding you?
At that time, as soon as I walked out, it was 4.
Okay, can you describe one by one how these security guards look, if you remember?
I remember it, but I can't describe the one who was behind me.
Okay, so where are these security guards surrounding you at this point?
When I walked out of the restroom, they were boxed around the door. So as I turned toward where my party was, now my back is to one of the guys. I can't tell you what he looked like.
Okay,
But the other ones, I know what they look like.
okay, so what happens after you see these security guards?
The one from behind grabs me by the neck in the chokehold,
Okay,
and the other 2 on the side grab my arms.
okay,
Just for the purpose of the record, is the one that grabs it from the behind the one you can't identify?
Judge,
Well, I'm trying,
no, counsel, is this an objection or?
well, it's an objection because it's a vague answer. He's,
Overruled.
okay.
You made it.
so can you describe the person that was holding your left arm?
Yes,
Describe them to the court.
he was big, he was dark skinned, he's in his room now.
Okay, and can you point them out?
He's the dark skinned black guy, bald head. He hasn't got a left arm.
Can you describe what he's wearing?
Uh,
I'm talking about the person you're talking about in the courtroom. Can you point him out and describe what he's wearing?
he has the blue, the red on the collar, like a sports jacket.
Judge, may the record reflect the identification of defendant number 2, Corey Spencer. The record will reflect the identification of Corey Spencer. Thank you. And can you describe the security guard that was holding your right arm?
Yeah, he was taller than Corey Spencer. He was light skinned, bald head. He was a big guy,
Was he African American or Caucasian?
African American.
Okay, can you see that person in the courtroom?
He's not here.
Okay, and then tell the court what happens next.
So I'm being choked from behind. I can't grab. He got my arms, and then one of the white guys, one of the white bouncers, he walked up and he just started punching me in the face.
Okay, can you describe this bouncer, this Caucasian
Yeah.
bouncer that you're mentioning?
I actually saw him as we waited for our booth to be clean. At that time, he had long hair. He had a Detroit Lions baseball cap turned to the back. He was wearing gloves. That's what had my attention from when we walked into the Coliseum. was that he had gloves on. So he had gloves on, he had a beard, he had long hair, and his baseball cap was turned to the back.
Okay, and you said this is the person who walks up and starts punching.
Yeah,
So that person, do you see them in the courtroom?
yeah, he's here.
Okay, can you point that person out and tell me what
He's
he's
in the
wearing?
middle.
Can you tell me what he's wearing?
Black jacket, white shirt, tie.
Judge, may the record reflect identification of defendant number one, Keith Whitmore. Record reflect identification. Thank you. And tell the court what happens after that.
So he was just punching at me, punching at my face,
When you say he, who are you referring to?
did more.
Okay,
I couldn't defend myself, and then at some point, the only thing I could do is try to keep him away from me.
okay, so let's back up just a little bit, Mr. Floyd. So when you say he was punching you, was it with an open fist or a closed fist?
I closed it
Okay, and where was he punching?
in the face, in the eyes. And he also, he was wearing gloves, and he also took his knuckles, and by this time, I can see blood splashing. And he took his knuckles and he was digging into my wound.
Okay, and do you recall how many times he punched you in the face?
Maybe 10.
Okay, and what happens after that?
Well, once I tried to keep him off of me, the two guys, the one guy who had me from behind in the chokehold, he released the chokehold. The two guys holding my arms, they kind of threw me down to the floor face first. And at this point, the fifth guy walks up.
Okay, can you describe who this guy who walks up?
Hold on.
Okay, thank you, Judge. Can you give a description of the fifth guy that walks up?
He was white, he was bald, he was in the courtroom today.
Okay, and can you point that person out and tell me what he's wearing?
He's behind, he's wearing black sweatshirt.
Judge, may the record reflect identification of defendant, Mr. Derek Ramsey. The record reflects the identification of Derek Ramsey. Thank you. And when Mr. Ramsey walks up, you said, what does he do?
So it happened once. When he first walked up, he was standing. So as the one was punching me in the face, Mr. Didmore stood next to him. He did nothing at first.
Who was he?
Mr. Abramski.
Okay,
He did nothing at first. He stood there and watched why this one was punching, the one in the middle was punching me in the face.
okay, and what happens next?
And once I kicked them away from me and they threw me down, that's when Mr. Abramski joined in.
Okay, so you kicked who away from you?
Mr. Didmore in the middle,
Okay, and who threw you down on the ground?
the two holding my arms.
Okay, and the two holding your arms, was one of them in the courtroom?
Yes.
And who was that?
The black guy bald head.
Okay, that Mr. Spencer.
Yes.
Okay, and what does Mr. Abramski do with this?
He started kicking
Okay, where is he kicking?
in the face, upper torso.
Do you recall how many times he kicked you?
I don't.
Okay, do you recall being conscious at this point?
I recall feeling like I was in and out of consciousness.
Okay, describe that to the court, what you mean you were in and out.
Because when they slammed me down to the floor, I went face first.
Okay,
So I kind of feel like for a second, I was out.
okay,
And at that point, I was trying to get back to my knees. They were kicking me in the face, and then they released my arms, and I'm laying face down on the floor. And at that point, I was trying to get up to my knees.
okay. Now, do you recall how long this assault lasted?
I really don't know, but I'll probably say if it was 3 minutes, it feel like it was 10 minutes.
Okay, so where were you at this time when this assault was being taken?
You mean the location?
Yeah, in the hood.
I was right outside the restroom door.
Okay, and from where you are, how far are you from your party, where they're sitting at the booth?
My party is probably 15 or 20 yards off, but they couldn't see me in that line of, in the line. Like where I walked down from the steps to make that left to go into the restroom, that walkway.
Your Honor, I'm gonna object to speculation on the part of the witness, what the party could or could not see. If he's being punched in the face.
Okay, counsel, that's enough.
Thank you.
All right, objection. I'm as to that part of this. Did you understand anything?
Yeah, I understood it, all right. So, Mr. Floyd, let me ask you, from what you could see, not from what anyone else could see, from what you could see your party at the booth?
No,
Okay, and what happens after you're let go and you're released to the booth?
the defendant in the middle, he grabbed me by the back of my collar and the back of my belt loop, and he drug me to a back door and threw me out the back door into the ground.
Pause. Thank you, Judge. So when you say the defendant, you're referring to Mr. Ditmore?
Yes.
Okay, and you said, can you repeat what you said? I'm sorry.
He grabbed me by my belt loop and the back of my collar and drug me out to the back door and threw me onto the ground.
Okay, was he alone or was he with someone else?
He was by himself when he picked me up, drug me to the back.
Okay, do you recall where this back door was?
It was right where it was, right behind where the restroom is. So the restroom was on the left and it's directly down that pathway.
Okay, and was this back door you're referring to located near where you were sitting at the booth with your party?
In that line of view, but further back is next to the restroom.
Okay, so in what direction is this back door? Is it in the direction going towards where your party is sitting or in the opposite?
The opposite direction.
Okay, so what happens after you're outside of the club now?
There was somebody from the Coliseum. I don't know, it wasn't one of the guys who sold to me, but he came out to the back trying to help me get up and get to the back, but I was able to get to my feet myself. I didn't know who he was or what he was going to do to me.
Okay, so at this point, did you call 911?
No,
Who did you call?
I
If anybody.
called my party inside.
Okay, and what happened after you called?
I couldn't get through to him, and I tried to call him a few times, but the call wasn't where I wouldn't get service, or they wouldn't get service.
So what do you do next?
I called a friend of mine,
Who's this friend?
Larry. His name is Larry Massey.
Okay, was he part of the party inside of the Coliseum?
No,
Okay, and after you called this friend, what did you do after that?
then I called my girlfriend.
Okay, at any point while you're standing outside of the Coliseum, did you call 911?
No,
Why not?
I didn't think to call 911.
Okay, so you called, your friend, you said Larry, Mr. Larry Mason?
Massey,
And then you called your
my
girlfriend.
girlfriend,
And who was your girlfriend at that time?
Erica Augustine.
Okay, and, you call and tell her what happened?
Yeah, I called and told her that she to come pick me up.
Okay, and what happens after you call and tell her to come pick you up?
When she arrived, she looked at me and said, "God, we went straight to the police station."
Do you recall, how long it took for her to get to the Coliseum?
Maybe 45 minutes to an hour.
So 45 minutes to an hour, you're standing or?
I'm standing in the front of the parking lot at the Coliseum close to 8 Mile.
Okay, during this 45 minutes to an hour, did you call anyone else?
I called my sister, and I made a few calls.
Okay, but at no point did you call 911?
No,
Okay, so what happens when your girlfriend comes to the house?
we immediately, drove down to the police station.
Okay, do you recall which, precinct you drove to?
No,
Okay, do you recall where the police station was located?
No.
Okay, do you recall how far the police station was from the Coliseum?
I don't.
Okay, so you go to the police station, and what happens when you get to the police station?
The guy, the attendant that was there, he looked at me and said, you need to go to emergency now.
Okay, when you say the attendant, who are you?
It was a police officer. He
I'm
was
going
sitting
to
in
object
front.
just for hearsay, Judge.
I was at that other thing. So, without telling me what anyone said, Mr. Floyd, when you go to the police station, did you do anything?
I went to the police station twice. The first time we went, we were sent to the emergency.
Okay, so this first visit to the police station was you and your girlfriend.
Yes.
Okay, and then you go to the hospital,
Mhm.
and do you recall which hospital you went to?
I don't recall.
Do you recall where this hospital was?
East side, Detroit somewhere.
Okay, so were you seen by anyone at the hospital?
Yes.
Okay, how long did you stay at the hospital?
Maybe an hour and a half.
You can have one. Right.
I couldn't hear what you said. I'm sorry, Judge, I couldn't hear what you said.
She asked to approach.
Oh,
I saw you put a sticker on it, but can we get the report for the market for us?
Oh, okay, yes, Judge.
I have some things on my desk and I don't know what case they're from, what date is, no date here. Or we take it or not.
Okay, Judge. May I approach now, Your Honor?
May.
Mr. Floyd, for the record, I just handed you some documents, and you're done reviewing those documents, put them face down and look up.
Your Honor, just as a point of clarification, I have testified as to medical records, but there's no foundation.
I'm sorry, I have no idea what it's looking at.
You're done, just put them face down on the ledge. Yeah, thank you. So, Mr. Floyd, I just handed you some documents, do you recognize what those documents are?
Yes.
And what are those documents?
Those documents This is my medical report.
Okay, and where did you receive a copy of those documents?
I believe I did.
Okay, where do you recall receiving those documents?
You said, when do I recall receiving them?
Where?
Where is St. John's?
Okay, and what date do you recall receiving those documents?
I don't know the date that I received them, but it wasn't the night that this incident occurred.
Okay, what date is those strike date?
Okay.
Strike date. Where do you recall receiving those documents pertaining to what's in it?
I had to drive to St. John's, to pick them up.
Okay, and what do those documents relate to?
Objection, Your Honor. You can't testify as to what those documents are. Maybe it's medical records, but there's no foundation.
Speaking objection.
I'm sorry.
I don't like speaking objections. I like old school objections.
Okay.
Objections.
Object is the foundation.
Objection, foundation. All right, those kind of objections I like. P45706. That's what they talk.
Well, I don't remember the number, but I know the word.
Objection, foundation. Respond.
I'll change the question.
All right.
What do you recognize those documents to be?
Object, a foundation, but we stipulated to the records already. We've already said on the record, we stipulate to those records.
All right, but then I think Mr. Farina asked for an opportunity to inquire before the court would admit the record.
Just the photographs. We didn't care about those.
Oh,
Right.
not the medical.
Right, the
record.
photo.
Oh,
But
right.
you can't testify to what they actually, other than their medical records. from
So the
St.
medical
John's.
records are, well, approaching. Let's go to the back right quick for a minute. Question.
Okay. I'm sorry.
Right. Right. All right. So having had a discussion off the record, Ms. Ritter, I believe these are the stipulated records, and so you don't need to lay a foundation. The parties have stipulated to these records that you're presenting to the court.
Yes, Your Honor. So at this time, Your Honor, the people need to look at People's Exhibit 1.
And these are the stipulated records, correct?
Yes, Judge, I believe so.
Yes, Your Honor.
No
Yes,
objection.
and we have
Okay,
Mr.
so then the court will receive People's Exhibit 1, which is the stipulated portion of the records, the witness medical records, but I still want to mark by the Court order.
May I approach Judge?
You may,
Judge, would the court like for me to give that support for the now mark
yes,
before I publish the support?
yes.
And I'm sure the prosecutor's office has supplied us all with copies of these exhibits.
I'm sure.
Oh.
She gonna try to use my, she gonna say yes and then she gonna try to. use
Okay,
my
I'm good.
word.
We got them, though, we get them. Okay.
So,
Hold on, you gotta wait for the front, for the court order.
Take a quick 5-minute recess. I just has to use the restroom.
All right, we'll take a 5-minute recess.
Judge, before everybody leaves, is it okay if, my OIC leaves and come back after lunch, or it looks like we probably won't get to it?
Oh, yeah, as long as he's here when you need him,
Okay, I haven't.
especially because we adjourned the whole trial for him.
We're going on vacation with them, Judge.
Next time we going. Next time we all going on vacation with us.
He's gonna blush.
All right, yes. And then we're on a 5-minute recess until 12:05. 12:05 according to that clock back here, because I think it's a little off. So that's off by 1 minute. All right. Ms. Hall, good morning. Unmute yourself. Let me- Oops, I keep doing, I'm sorry, it's my fault, Ms. Hall. Unmute yourself again. I'm sorry.
Good morning, Your Honor.
Good morning. Ms. Hall, all of the lawyers from the defender's office are in a breakout room right now. And I brought you out of the waiting room though to ask you if you wanted to go ahead and proceed. Mr. Thomas is the stand-in probation officer today, and he did indicate that you will be, he's recommending you to be discharged from probation. So are you comfortable proceeding without the lawyers?
Yes.
Okay. All right, this is case number 1958925, the people of the state of Michigan versus Glenda Hall. The defendant is, oh wait, this is Mr. Quinn anyway. Your lawyer was Mr. Quinn?
Yes.
Okay, well, he's not checked in either, and I'm gonna go ahead and so are you still comfortable? Because it was Mr. Quinn, but he didn't check in, and it's still a recommendation for discharge.
Yes.
Okay, so this is, the defendant is charged with disorderly person, and today is the date set for review. Appearances, please.
Joseph Thomas on behalf of the probation department, Your Honor.
And then your name, ma'am.
Glenda Hall.
Okay, today is the date set for review. Mr. Thomas?
Good morning, Your Honor. This defendant was placed on a term of 12 months probation back on September 26, 2019. In that time, they were to attend 6 weeks anger management and continue with mental health services that they were seeing at the time. They were also to pay $1,110 to the court. Probation is happy to say that the defendant has complied with all the conditions of probation. They have paid all fines, costs, and fees owed to the court. They have no new offenses per a criminal history check. At this time, the probation department would recommend that she be discharged from probation. This is a standard probation. I don't see any MCLs checked off
great.
here.
Okay, then today is the date set for review, and Ms. Hall, the probation department has indicated that you have completed all the terms and conditions of your probation satisfactorily. Congratulations. The court is therefore satisfied, and I will discharge you from probation with improvement, and close the case out. Ms. Hall, we are live on YouTube, so please give me the numbers only, the numbers only to your street address.
18620.
Madam Clerk?
That's correct.
All right, we will send you a copy of the probation discharge to that address, okay, ma'am?
All right, thank you.
All right, you're welcome. Have a great day.
You too.
All right. And it looks like Mr. Murad is back. And so I'm going to go back on the record with respect to Mr. Watkins. All right, so we're back on the record with respect to case number 1761404. Appearances again, please.
Good morning, Your Honor. Derek Farmer on behalf of probation.
And Ryan Murad, PA 3665 on behalf of Mr. Thaddeus Watkins.
And your name, sir?
Good morning, Your Honor. Thaddeus Watkins.
Okay, Mr. Farmer?
Your Honor, today is the date time set for review for Mr. Watkins. He has been on probation since 2019. He was ordered to complete parenting classes and anger management classes, as well as community service. To date, we have proof of the defendant completing the 40 hours of community service, as well as he is continuing into the anger management. I do believe he have roughly 6 or 7 classes before he's completed with that. The parenting classes, however, I'm not showing that has been completed yet.
All right, so you said he has about 6 or 7 anger management classes left?
Yes, Your Honor.
Okay. And then was he imposed any fines and costs?
The fines, costs, and fees, I believe, were taken care of because of the community service, Your Honor.
Yes, okay, and then what about drug screening? He wasn't ordered drug screening?
He was ordered to drug screen. We just re-referred him out. Drug screens prior to the shutdown were negative. We never had any issue with him.
Okay. All right, great. Mr. Murad?
Your Honor, so after a conversation with my client, he indicates that he has completed his anger management classes. However, does, like Mr. Farmer said, have 8 more parenting classes to complete. I don't know if we can, if we have to reach out to Eve or if Mr. Watkins has anything he can send over to Mr. Farmer. But we're just going to be asking for an 8-week adjournment for him to finish those parenting classes. And by then, I believe he'd be able to have all the proof over to Mr. Farmer.
Is that where he was doing the anger management, was through eBay?
Yes, Your Honor.
Mr. Watkins.
Okay, so then, yes, okay, so Mr. Watkins, you need to coordinate with Mr. Farmer to make sure that he has the proof from eBay. Make sure eBay has record that you completed the anger management. My philosophy is that if there's no record of it, you didn't do it. So even if you went there, if you forgot to sign in or they didn't, I mean, somebody has to send me proof that you completed those classes. Yes, Mr. Watkins.
What is the evade that you're talking about?
He said you were supposed to do, how many weeks was he supposed to do?
12, Your Honor.
So you were doing 12. Miss Yider, let me put her in the waiting room. She is walking all the way around. I can't do that. Okay, you were supposed to complete 12 weeks of anger management plus parenting classes.
Correct. I completed the 12. I'm sorry.
Right. Mr. Farmer says he doesn't have record that you completed the anger management. So you need to make sure that eBay sends him proof of your completion of anger management so that you don't have to repeat it. Because my position is that if there's no proof, you have to repeat it. So somebody got to give you a completion certificate. Okay?
Okay, is eBay the Pam's place? Is that the same thing we talking about? Because
no.
Pam's place. It looks like he was taking them both at Pam's place. He was referred to eBay, however, he went to Pam's place.
Oh, so he was taking Pam's place for anger management and parenting?
Yes, Your Honor.
Okay, so then Pam's place. So forget what we said about eBay. Then
okay, that's why I was confused.
Okay, you're doing it at Pam's place. So Pam's place has to give us proof that you completed the anger management, and then you can finish the parenting classes. So it seems like you've done everything, and now I'm also clear as to why it's on this docket and not Judge Garrett's docket. So we're going to adjourn. This is, all right, so let's adjourn 1, 2, 3. That puts us in March. Madam Clerk, what do I look like on those Thursdays in March? Maybe the beginning with the second Thursday, the 11th, 18th, and 25th. Which is the best day for me?
The 11th, you don't have anything.
All right, we're going to set the review. I'll extend this probation to March 11th. And the review will be at 9:30. And as long as you've completed those classes and we have proof of the completion of the anger management, then the court will discharge you from probation. And this case will be dismissed and removed from your record, okay?
Yes, ma'am.
All right, so I'll see you March 11th. And then Mr. Farmer, you have his contact information, correct?
Yes, Your Honor.
All right, then we're all set. Thank you and have a good day.
Thank you.
All right. All right. I'm gonna admit the jail. And then are we ready on Mosley?
Yeah, I'm Mosley, Your Honor.
And I believe that's it for me, Your Honor.
Oh, okay. Well, good to see you.
Good to see you.
Mr.
Happy
Farmer.
holidays.
Happy holidays. Okay, this is Mac Shekels, case number 1846298. The defendant is charged with assault and battery, and today is the date set. Y'all, complete heart at that jail. Oh my. Okay. Sir, go ahead and say your name so I can mute you.
My name is Max Shackles.
Whew. All right. And today is the date set for pretrial. Appearances, please.
May it please this honorable court, Darnell Barton, P 83363 on behalf of the people, Your Honor.
And for the record, Your Honor, Janice Stevenson, P57708, appearing on behalf of Max Shekels, who is incarcerated in the Wayne County Jail and appears via Zoom.
All right. And I've already had Mr. Shekels say his name. So today is the date set for pretrial. How are we proceeding?
Thank you, Your Honor. We have
No, not you, Mr. Berry. Not
I'm
you.
sorry.
I'm sorry. I'm on Mr. Shekels.
Sorry, Judge.
That's okay. Ms. Stevenson, how are we proceeding?
Thank you, Your Honor. On behalf of Mr. Shekels, Your Honor, we believe there to be no complaining witness present. And I think that should be a Miss Stanleyuna Rayford and Mr. Stanley Rayford. Those complaining witnesses not being present today, Your Honor. Today's pretrial conference having been set, I believe, December 23rd. We would move that this matter be dismissed for complainant's failure to appear. In the alternative, Your Honor, Mr. Shekels will continue his plea of not guilty. We respectfully ask that today's pretrial conference be adjourned for the shortest period of time possible, that the complaining witness's presence be required at that next pretrial date, Your Honor.
Mr. Barton.
Yes, Your Honor. I don't have any information on my file here that says they appeared on the, I believe, the January 2020 date. This was a year prior to this date. But I do know that we talked to the complaining witness.
That keep walking past my camera while we in court. Okay, I'm sorry. You said what?
No problem, Your Honor. Essentially, what I'm saying, Your Honor, is that we spoke with the complaining witness prior to COVID, who is also the defendant's, the defendant's father-in-law. So he just essentially wanted to propose a deal to help the young man. So I would respectfully ask for another opportunity for him to appear should he need to, so that the plea deal that we offered prior to this date, which was anger management and drug screening, I believe that might be beneficial to the defendant in this case. So we would respectfully ask for another opportunity to have the complaining witness appear so that we can continue with the pretrial agreement.
So based on Mr. Barton's comments, that means that Mr. Shekels had KPS before? Why are we here? Okay, so it was scheduled for a pretrial pre-COVID. Now we're here and he obviously has been arrested on this warrant. And so the complaining witness, you don't know if they appeared before, but even if they did, enough time has passed where I would want them to appear again or to express their intentions. So one, I'm going to deny defense counsel's motion for dismissal. I will grant the people's request for an adjournment to communicate with the complaining witness, and then we will see if they appear the next time. So today is the 7th. We're going to set it for the 28th. I think, have I reached my maximum on the 28th yet? Yes, no, you have 2 more left.
Okay, we're gonna set it for January 28th at 8:35, and the complaining witness must appear. Asked to bond, Ms. Stevenson?
Yes, the current bond, which I believe to be $100. I think it's personal, Your Honor. Just ask that the current bond be continued.
Oh, okay, so he's been held on something else then.
Correct, Your Honor.
All right, the bond will continue with no contact with complaining witness. All right, then we're all set with Mr. Shekels for the 28th. If he, I mean, they just bless, okay, blessings for call. They just feel like they walk past that camera like it ain't on. Deputy, can y'all stop walking past the camera? Mr. Shekels is in court.
Your Honor, we can stop walking past the camera. However, the setup we have is not ideal. So we're doing the best that we can, Your Honor.
Oh, okay. So you trying to get work. Well, why can't y'all put his chair closer to the camera? Then y'all could at least walk behind him. Y'all can't do that?
No, we can't, Your Honor. There's literally there's literally an arm's length here. I'm not gonna have him run on top of the camera.
Oh, okay. Well, okay. Well, then I won't be so anal then. All right.
Thank you.
Okay. I forgot. I lost my train of thought because they was walking past. What was I saying? Oh, so whatever he's being held on, whatever you're being held on, if he bonds out, Mr. Shekels, you need to make sure that you have the Zoom information for your court date for the 28th. So if you bond out on the other case, I don't know what that case is and what your bond is, but if you bond out, if it gets dismissed, whatever happens, make sure that you get the Zoom ID number for Judge Bryant so that you can Zoom in on the 28th so that we don't issue another warrant for your arrest on this case, okay? You're muted.
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right, then we're all set with Mr. Shekels, and we'll see you back on the 28th at 8:35. Complaining witness must appear. Have a good day, sir.
Thank you, Your Honor.
You're welcome. All right.
Excuse me, can I ask my attorney one question?
You can. I'm going to send you to a breakout room. I'll send you to the breakout room and you can talk to the lawyer.
Thank you very much, Your Honor.
All right, so I'm just going to send them back to number 1. All right. So you can go to number 1. I'm getting ready to do this retained case. Oh, Mr. Mariah here anyway. Okay, so this is Povish. I'm ready on Povish. This is case number 2045749. The people of the state of Michigan versus Scott Allen Povish. The defendant is charged with operating while intoxicated, operating with a high BHC, and possession of a gun while operating under the influence. And today is the date set for final pretrial appearances, please.
May it please this honorable court?
Not you, Mr. Barton. It's
Oh,
Mr.
I'm sorry. This is the wrong guy. I apologize.
Yes.
Good morning, Your Honor. Joshua Holman on behalf of the people, P number 71971.
Good morning, Your Honor, to you and your staff. Brian Berry, appearing on behalf of Mr. Povish, P76788, Your Honor.
And Mr. Povish, your name for the record?
Good morning, Your Honor. Scott Allen Povish.
Okay, Povish. All right, Mr. Povish, we're going to get it correct. It's a short O and not a long O. Okay, today is the day set for final pretrial. How are we proceeding with respect to Mr. Povish?
Thank you, Your Honor. My client would like to avail himself of the people's offer.
And what is that?
Your Honor, we've made an offer to Mr. Povish that if he wishes to plead guilty to count 1, the people will reduce that charge to an operating while impaired, which has a statutory maximum penalty of 93 days. We would also dismiss counts 2 and 3. In exchange, we would agree to a sentence of 1 year probation to include psych and alcohol evaluation and to follow up with recommended therapy and random alcohol testing. The defendant shall continue with alcohol counseling and AA meetings that he is currently seeking. No driving for 6 months except for work if his license is not suspended, and restitution to the property owner, no plea under advisement that people are asking for, and fines and costs left to the court, Your Honor.
I'm sorry, you said no plea under advisement?
Correct.
Oh, okay. Okay, and so, counsel, I'm assuming that you haven't submitted a signed advice of rights form to the court.
Yes, Your Honor. The advice of rights form was on the plea form there, and I had my client initial next to his advice of rights.
And did you send that to my clerk?
Yes, Your Honor.
Oh, okay. Madam Clerk, did you send that to me?
This morning.
Okay, thank you. I'll pull it up. Yep, there it is. Okay. All right. Okay, so I'm going to share my screen, Mr. Pavish, and then that's it, I think. Yes, okay. Mr. Pavish, I have shared my screen. Do you see what I have shared on my screen?
Yes, ma'am.
And sir, is that your signature on the bottom?
Yes, ma'am.
And with respect to your signature, sir, did you read or go over these rights with your lawyer?
I did, ma'am.
And do you understand your rights?
Yes, I do.
Sir, do you understand that this is a misdemeanor and therefore you do have a right to a trial? By pleading guilty, however, you will be giving up your right to a trial.
Yes, ma'am.
Do you understand that by giving up your right to a trial, that means your lawyer will not get to call any witnesses on your behalf, and your lawyer will also not get to question any witnesses that are called on behalf of the prosecution, and that the court will enter a guilty plea on your behalf. Do you understand that?
Yes, ma'am.
Has anyone threatened you in any way or promised you anything to get you to plead guilty today?
No, ma'am.
Do you understand, as is stated in number 3, that you may be giving up your right to an appeal if you plead guilty?
Yes, ma'am.
All right. Sir, raise your right hand for me, please. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. Counsel, who's going to voir dire, because I don't have information.
You want me to do it, Josh, or Mr. Holman?
Whatever you prefer. I can do it, or you can do it if you're prepared.
Prepared. Mr. Pavish, on or about May 11th, 2020, were you operating a motor vehicle in the location of 18700 Fitzpatrick Street?
Yes, sir.
Was that the city of Detroit, county of Wayne?
Yes, sir.
And at that time, prior to operating that vehicle, had you consumed any alcohol?
Yes, sir.
And did that impair your ability to operate that vehicle?
Yes, sir.
And had you had your faculties about you, would you have had better control of that vehicle?
Yes, sir.
I'm satisfied, Your Honor. I don't know if Mr. Holman has anything to add.
Mr. Holman, are you satisfied?
Did you say, I have May 1st. Did you say May 11th?
May 1st, excuse me.
If you didn't say May 1st, May 1st. The people are satisfied with that, Your Honor.
And so is that the correct date of the offense, May 1st?
Yes, I have May 1st, Your Honor, on the report.
Yes, May 1st is the correct date, Your Honor. I apologize.
Okay, and so Mr. Pavish, you agree that it was May 1st?
Yes, Your Honor.
Okay. The court is satisfied, and I will accept a guilty plea to 1 count of operating while visibly impaired. In exchange for that plea, the court will dismiss counts 2 and 3 and amend count 1. With respect to sentencing, Mr. Pavish, the court is going to schedule your sentencing for another day because I would like a pre-sentence report, and the law requires a substance abuse evaluation. So I'm going to order the substance abuse evaluation and the pre-sentence investigation. And then, Mr. Berry, your client is consenting to being sentenced via Zoom?
Yes, Your Honor.
All right, then I'm going to set the sentencing for, if you're available, February 11th is a good day for the court.
That works, Your Honor.
All right, so we're gonna set the sentencing for 9:00 a.m. on Zoom, February 11th. Right, I'm sorry. Am I getting my months mixed up? Is February 11th a good day for me?
Let me check again.
I might be getting my months mixed up. That might have been March 11th. She told me I was good.
Yep, it's March 11th.
Oh, so I don't want to go that far out. I didn't think, what do I?
On the 11th, you have 11. You have 18 on 11.
What do am I better on the 18th or is it about the same, February? Because you have to remember that they're gonna put pretrials, the magistrates are gonna put pretrials on there too.
You're better on the 11th.
Okay, let's keep it the 11th. Let's keep it the 11th, okay? All right, February 11th at 9:00. And then, counsel, was your client's address or phone number on the plea recommendation?
I don't think so, Judge. Do you want me to email Ms. Muldrow?
Email her the address and phone number for your client so we can make sure that probation is able to get in touch with him for the pre-sentence investigation.
I sure will, Judge.
Okay, then we're all set until the 11th. Everyone have a great day.
Thank you, Your Honor.
And Happy
Thank you,
New Year
Mr.
to
Holman.
you all. Happy New Year.
Happy New Year.
Happy New Year to you, Judge. Thank you
All
very
right,
much.
you're welcome. Okay, Mr. Thomas, I'm gonna get, who else do you have?
I also have Antonia Burnett and Antonio Howard. I don't believe he's here, but I thought you had said earlier that Miss Burnett was.
Yeah, Miss Burnett is, and we did Glenda Hall. Let me cross that off. Okay. I'm gonna bring in Antonia Burnett and I'm gonna bring in Mosley and the complaining witness.
Judge, can you bring Aubrey Howard so we can see if that's the Howard we're looking for?
Mm-hmm.
Please, thank you.
Okay. All right, so I want everybody to keep yourself muted unless I ask you to unmute. Oh, wait, I brought in the wrong person. Now I brought in Goldston. I didn't mean to do that, but I'll leave him here. Did you already speak to Goldston?
All set on Golston, Your Honor.
That's not on my docket. Oh, yes, it is. Yes, it is. I'll leave him here.
Thank you, Your Honor.
Okay, so this is Jacqueline Mosley. This is case number 2045952. The defendant is charged with assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
And please, this honorable court, Darnell Barton, P83363 on behalf of the people. And for the record, Your Honor, I have the complaining witness here, Ms. Stephanie Yater. Yater, I apologize. Ma'am, can you unmute yourself and just state your name for the record, please? Ms. Yater, can you unmute your phone and just state your name for the record?
Stephanie Lynn Yater.
Thank you, ma'am.
Bless me. Okay.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Jacqueline Mosley. Ms. Mosley, will you please unmute and tell the court your name?
Jacqueline Mosley.
Okay, today is the date set for a pretrial. How are we proceeding?
Your Honor, having had negotiations with the people, we would like to avail ourselves of the people's offer, asking the court to adjourn this matter to 16 weeks, Your Honor, to give Ms. Mosley an opportunity to engage in some alternative dispute resolution and complete 12 weeks of anger management. At that time, I believe there would be no objection to our motion to dismiss this matter.
Your Honor, if I may.
You may.
I apologize for interrupting. And Ms. Stevenson, and I apologize, maybe I didn't state that the mediation portion of it as well. I don't know if I had that in there, and I do apologize, but I expressed that to Ms. Yater about a possibility of mediation so that they would be able to interact at the Team Wellness Center should they need to utilize the facility. So if that's okay with you, I do apologize if I didn't relay that
That's
to you.
okay. I think it's a great idea. I think that's okay.
Thank you. And I've already talked with Ms. Yater, and she is compliant with that. She has done. She's willing to do that to help Ms. Mosley as well. So
Thank you. And that's actually a minor detail to which I believe Ms. Mosley, once I have an opportunity to review that with her, will have absolutely no objection.
Okay, so then what about April the 8th or April the 15th?
I'm just wondering if that's enough time for us
Well,
to get.
you said 12 weeks of anger management, so I counted, that's a little longer than 12 weeks, but we can go to the end of April, the 29th.
If we could do that, please, Your Honor.
All right, so April the 29th. At 9 o'clock via Zoom, final pretrial. The complaining witness has appeared today. Therefore, ma'am, you are excused from the final pretrial, meaning you don't have to appear, but you may appear. You may appear at any scheduled court appearance, but you are not required to appear because you appeared today. Okay, anything further?
nothing from the people, Your Honor. Thank you.
I will forward to Ms. Muldrow contact information for Ms. Mosley. I believe Ms. Muldrow is going to need that for Mr. Yider, Ms. Yider also, so that she can get information over to Wayne County Dispute Resolution Center. And other than that, I have nothing further.
All right, you all make sure she gets that.
Yes, I will.
Thank you, Your Honor.
Thank you very much, Your Honor. Thank you, Mr. Barton.
Yes,
all right. Thank you, and you all have Ms. Yater and Ms. Mosley, have a good day.
Mosley, I'll be giving you a call later this afternoon, ma'am.
Thank you.
You're welcome.
All right, I'm ready on Burnett. This is that Howard person still hasn't connected. This is case number 2056318, the people of the state of Michigan versus Antonia Yolanda Burnett. The defendant is charged with license plate illegal use. And today is the date set for a review. Appearances, please.
Joseph Thomas on behalf of the Probation Department, Your Honor.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Antonia Burnett. Your Honor, my recollection is that Ms. Burnett had been represented in this matter by counsel. I think it was an attorney, Robert Plumpy.
Yeah, it is, but I'm thinking that she, I'm believing, this is what I'm believing, that Mr. Plumpy was appointed to her on the felony. They reduced it to the misdemeanor, and now she should be represented by defender's office. Ma'am, was Mr. Plumpy your hired attorney, or did he get appointed to you by the court?
He was appointed to me by the court.
Right, so now it will be the defender's office. But at any rate, I had a conversation with Mr. Thomas while we were waiting for you all to come out of the breakout room, and Mr. Thomas indicated to me that Ms. Burnett kind of fell through the cracks, and she had not been assigned a probation officer until just recently. Today is her 3-month review. So what I'm going to do is just continue her to her final review. And maybe, I don't remember what the conditions of her probation are, but if she can get it done in this 3 months, I'll still keep her on track to be discharged at the end of the 6 months. So Mr. Thomas, do you all now have Ms. Burnett's contact information?
We did before. It appears that just she was not properly assigned a PO. So actually, I'm going to contact Miss Burnett today. I just want to help her get set up for the drug testing.
Right.
That's the main thing, because the other stuff, it looks like it was mostly just paying money.
Yeah,
And
okay.
so
And she did, Mr. Thomas told me that she did reach out to probation. But of course, we were probably caught up in the holiday schedule. So I'm trying not to penalize her for that, for not getting assigned a probation officer. So I do want her to get the stuff done. So Mr. Thomas is going to contact her today. We're going to switch over from Mr. Plumpy to the defender's office. And then Ms. Burnett, do you have, Mr. Thomas, you said you do, well, let me just do this.
I have her phone number.
Okay, so you
send in the chat to me, and then I'll have it. We'll be
I'll
on.
text you.
That's even better. Thank you.
Okay, so they're gonna make sure that the defender's office has your phone number, and then we'll get you on track. I want to commend you for reaching out, because I think everybody should do that. So I commend you for reaching out to us, and we're gonna get you on track. Okay, so I'm gonna, what is her final review date, Madam Clerk?
April 1st.
Okay, and is that on a Thursday?
Make sure.
She was assigned to Officer Metz. I'm not sure what day that it is.
She was assigned to Metz.
April 1st is a Thursday.
So let's actually move her to, Metz is on Wednesday. So then let's move her to a Wednesday. Well, what's the following week after April 1st?
April 5th.
Let's move her to April 5th at 9:30. Okay?
So Miss Burnett, just look for my phone call. I'm going to call you probably in the next half hour here, okay?
Okay,
All right. All right, I'll see you in April, ma'am. Have a good day.
thank you.
You're welcome. Okay, Ms. Stevenson, for some reason, I don't know why Ms. Mosley is in the waiting room.
I think that's it for me, Your Honor, because the only other guy I had, he didn't show up. But I was going to ask on his matter. I tried to stick in a violation yesterday for him, Mr. Antonio Howard, because he's done just about absolutely nothing on probation for this past year.
Okay, so did you send that to Ms. Muldrow?
I believe so. I gave it to our clerk here. I believe it was sent to I don't know if it got there
Okay,
this
Ms.
morning or
Muldrow,
yesterday, though.
Did you get a show cause request for Mr. Howard?
His last name is Howard.
Yeah, Tonio Howard, the one, he's on our 9 o'clock. He's at 9 o'clock.
I did, and I forwarded it to you. No, I didn't forward it to you, but I
Okay,
will
so
now.
forward that to me in the paperwork. Don't do a separate, like forward that in the paperwork, so then I'll sign it. Okay. All right,
Thank
then
you.
you're all set, Mr. Thomas. Have a good day.
You as well.
All right, I have Mr. Goldston on screen. I have Mr. Goldston on screen and in the waiting room. What's that about? Mr. Goldston, can you hear us? Oh, well, I'm gonna remove this other device. You logged in on 2 devices? Oh, I'm gonna remove the other one. Okay, so we have Goldston, and then we have Navarra, and then we have an unidentified. I'm gonna bring in those 2, and then who's gonna go to the breakout with the unidentified?
I think my guess is gonna be that's Mr. Farina's client, Ramesses Nakle.
Oh. Well, who told me? Oh, they submitted a discharge. Mr. Farina didn't show. Okay, let me put them back. Okay. All right. So I'm ready on Goldston. This is case number 2045805. The people of the state of Michigan versus Roderick Louver Goldston. The defendant is charged with assault or assault and battery. Today is the date set for pretrial appearances, please.
May it please this honorable court, Darnell Barton, P 83363 on behalf of the people, Your Honor.
For the record, Your Honor, Janice Stevenson appearing on behalf of Roderick Golston. Mr. Golston, please unmute and just tell the court your name, sir.
I'm gonna help him unmute. Hold on. Okay. All right, your name, sir?
Roderick Golston.
Okay, today is the day set for pretrial. How are we proceeding?
Your Honor, on behalf of Mr.
I'm sorry, Ms. Stevenson, to interrupt you. Madam Clerk, can you call Mr. Strike that, don't call him. Do you have in the file a discharge for Mr. Knockley?
Mr. Farmer's on his way to bring one down.
Okay, all right, thanks. Okay, Ms. Stevenson, continue.
So, Your Honor, I believe that today's pretrial conference was set on December 3rd. And I do not believe the complaining witness Carlos Ortiz to be present today's hearing. That being the case, we would move that this matter be dismissed for complainant's failure to appear. In the alternative, Your Honor, we would ask that today's pretrial conference be adjourned to the court's earliest date and that complaining witness Carlos Ortiz be required to be present in order for the people to move forward.
Mr. Barton?
Yes, Your Honor. I'm actually looking at this, and that's correct. I believe this is this was scheduled prior. So the people would just ask.
What you mean
again,
it was scheduled prior? It's at 8:30 on my docket.
December 3rd, correct?
No,
Oh,
he
I'm
was
so sorry.
arraigned December 3rd. Was he arraigned?
He was arraigned on December 3rd.
Got it.
Right,
Okay.
so it wasn't on
So,
my docket previously because it's at 8:30.
yes, Your Honor, appreciate that information. So the people would again just ask respectfully at this point if we would have the opportunity to have him appear again, Mr. Carlos Ortiz. So respectfully, we would just ask for another opportunity, and if you do decide to dismiss, that you would do so without prejudice.
Today is a day set for pretrial. The complaining witness has failed to appear. This is the first scheduling for pretrial. Madam Clerk, did you say I had one more space on the 28th?
Yes.
The court is going to deny defense counsel's motion for a dismissal and grant the people's request for a one-time continuance. I'm going to continue the matter to January the 28th at 8:35. If the complaining witness fails to appear at that time, then the court will reconsider the motion for dismissal.
Thank you, Your Honor.
You're welcome. Anything further?
Nothing
No,
further
thank
before
you, Your Honor.
All right, you're welcome. Have a good day. See
Thank
you
you.
on the 28th. You're welcome, sir. All right, I'm ready on Navarra. This is case number 2044371, the people of the state of Michigan versus Miguel Navarra. The defendant is charged with assault or some battery. Today is the date set for final pretrial appearances, please.
May it please the court, Darnell Barton, P 83363 on behalf of the people, Your Honor.
And Ride Murad, PA 3665 on behalf of Mr. Miguel Navarra. Mr. Navarra, if you can unmute yourself and state your name, sir.
Miguel Navarro.
All right, today is the date set for final pretrial. How are we proceeding?
So, Your Honor, if I'm correct, pardon me for interrupting, counsel. So, Your Honor, if I'm correct on this one, I have in my notes here that the complaining witness was to appear today. We had information that they were incarcerated in a jail in North Dakota. I have not been able to be in contact with them at that point.
The complaining witness is incarcerated in North Dakota?
That's correct, Your Honor.
We move for
Well,
dismissal.
at the time that we spoke with them, I apologize for interrupting you, Counselor. At the time that we spoke to them for the original pretrial, which I believe was, I don't want to give the incorrect date, but it might have been in July. And so we reached out again to no avail, Your Honor. So I'm not quite sure where the witness is at this point.
Okay. Mr. Marat,
Respectfully move for dismissal and thank you, Brother Prosecutor.
today is the
If I
day
may,
set
Your
for
Honor.
final. Oh, go ahead.
I apologize. I just wanted to ask on behalf of the people, if you do decide to dismiss, that you do so without prejudice.
Yes, always. Well, not always. I guess there are some circumstances where it wouldn't be, but today is the date set for final pretrial. The complaining witness was required to appear, has failed to appear. The people, the court does take note that the people have indicated that the complaining witness may be incarcerated in an out-of-state prison facility. And I do take that into consideration. However, the court is going to grant defense counsel's motion. I'm going to dismiss the matter. It is a dismissal without prejudice. Mr. Navarro, that means that if they locate that witness and the witness still, can proceed with the case, then the charges may be reissued. So if you get something that says, this case has come back up, don't ignore it and say, no, the judge dismissed it. I'm dismissing it without prejudice, which means they could reissue it should they locate that witness, okay?
I understand, Your Honor.
Okay, all right. And then Mr. Navarro, we're going to mail you a copy of the dismissal. We are live on YouTube, so I don't want you to give me your full address, but can you please give me the numbers only to your street address?
That'll be 5502.
Madam Clerk, is that what you have?
No.
All right, Mr. Navarro, do you have something that you can write the court's phone number down?
Yes, ma'am. Hold on a second.
Okay.
I'm ready.
Okay, it's 965.
965.
And of course, it's area code 313, but it's 965-2295.
95. Okay.
So call the courtroom so that you can give my clerk the address you want us to mail a copy of the dismissal, so you'll have it for your records, okay?
Okay. Thank you very much.
You're welcome. Have a good day.
You too, man.
Bye-bye.
Bye.
All right, let's see if this Mr. Howard, this Aubrey Howard person, I don't know why they're not in video. And then Mr. Ramsey's don't have video or sound, so I can't even do nothing with him. So I'm gonna remove him. And then I'm gonna give Aubrey Howard about less than a minute to unmute. Okay, and then Aubrey Howard, why you don't have video? We can't see you.
Oh, okay. Why is that? Let me see. The post has opened.
And then the other question while you're trying to figure out your video is we don't know who you are in terms of you're not on our docket. What is your name, Aubrey Howard?
My son, Tonio Howard, he was scheduled for review today. And I was seeing if he was in court because he was incarcerated, but I haven't heard from him. So I thought maybe I could see him today in court.
Okay, thank you for that information. So where was your son incarcerated?
He was incarcerated at the detention center.
Okay, so
and he's a mental health patient.
Okay, is he, well, strike that, never mind. Okay, so no, he's not here.
Okay.
So Ms. Stevenson, can you contact the detention center and then we can see if I'll adjourn him. Who was his probation officer, Ms. Muldrow? Not you, Ms. Howard.
Oh, okay.
My clerk.
Thomas.
Okay, so, right. All right, ma'am, I'm going to send you to a breakout room with the speaker's office. And then they can get your contact information, and Ms. Stevenson will, because he's scheduled for review, so I was gonna just adjourn him anyway.
Okay,
They didn't bring them. So Ms. Stevenson,
okay,
she'll have to do a little bit of checking. So I'm gonna
okay,
send you to a breakout room with the lawyer, and she can get your contact information, and then she can contact you. So,
okay, thank you.
all right, so you have to accept to join the breakout room.
Okay.
Well, ladies and gentlemen, that is it for today. Tomorrow starts the case of the state versus Sarah Fuson in Judge Wolf's courtroom. So, ciao, ciao, and ta-ta, and I'll see you guys again tomorrow.